Hello everyone. Today's lecture will be conducted by Advocate Prem Kamath sir. He is a practicing lawyer at Kerala High Court. Over to you, sir.
Thank you so much.
Yes.
Welcome everyone. We have a fairly large audience today. I would request all of you, if you have any questions, to please raise your arms on the virtual way, and I would be only happy to address the question and then move forward. Feel free to ask questions, and I think we can start. First
Yes,
come
sir.
first.
Yes, sir.
Yes.
We can start.
Yes, thank you.
Okay, thank you.
First come first. I see a fair amount of participants who are lawyers, so that makes it more interesting and challenging both, and students of law as well. Once more, I welcome all of you. To start with the session, the first question that props up in our minds when we think of digital evidence is, what is digital evidence or what is electronic evidence, etc. So coming to this, I've just shared a slide screen with you. The definitions which have been posted there is just for information's sake, just to wake up your minds to, start the thought process as to what is evidence, what is digital evidence, what is electronic evidence, etc. I don't intend that you need to by heart this or you need to take it to your hearts word by word, but just for a basic understanding as to what could be a definition, if at all, for an understanding of what is digital or electronic evidence. So we have two definitions and the sources of those definitions before all of us here. From my end, if I would try to explain what is digital or electronic evidence, it would be like any information or data which is relevant to any set of facts or investigation or case or proceedings, which is either stored, received, or transmitted by an electronic device. So maybe I have just taken a bit of things from here and there and then joined it up to make it as simple as possible. Well, having said that, the next question that crops up in my mind as a student of law as well is, what is so special about electronic evidence or digital evidence? Or to reframe it, is there anything so unique or special with regard to digital or electronic evidence? Any takers? Any takers for this? Is there anything special? Do you feel that is there anything unique, or is it just the same as any physical evidence that we normally are catering to? Any takers, please? Yes, Mr. Viran, that's a very valid point. It can't be destroyed. Well, it has a debatable topic.
It can be retrieved.
Sorry?
It can be retrieved.
Yes, it can be retrieved. Yes. Anybody else? Difficult to be destroyed, Nikhil Gankar. Yes. Once more, please.
It is in the cyber world. It cannot be, we cannot touch and we cannot, but we can imagine that something is there.
So you mean to say the intangible aspect of it?
Right, tangibility and intangibility.
Exactly. Fine, great.
It can be, means we can imagine that something is there, but we cannot physically, physically, we cannot hold the data in hand, like, physical things.
Exactly.
So
That's why
cyber-
that's the intangible aspect of it. We can sum it up in a word,
Right,
intangible.
right.
Yes.
Right, sir.
Yes. Very technical. Yes, it is technical. Why do you feel it is very technical? Can you give me an explanation, please? I'm not getting your name here in the chat, but it's stated as PLF. When you say it's technical, yes, I do agree it's technical, but could you give me a bit of an explanation or elaboration as to what you intend by saying it is very technical? Virtual.
In fact, I'm sorry, sir.
No, go ahead. Go ahead. No issue. Please go ahead. Process involved in getting it is technical. Yes, true. Very true. So we have all the thought or all the thinkers with us who have participated have given their own inputs, which are very true, very correct. Now let's move and see what is there, which probably I in my terms of thinking, just to share my thoughts as well. I don't know why yes, now it changes. Now these are some words and phrases which I have jotted down. If you could just go through the screen slide which is shown at the moment. All of these are somewhere what we have discussed at the moment by what your thoughts that were shared. So in short, we can sum up that what all our thoughts are somewhere on the fact that yes, digital or electronic evidence has a bit of a uniqueness in it, which is different from the normal physical evidence that we are normally used to under the Evidence Act. So with that, we move forward. I will not take much time in elaborating it because I believe the thought process is fine and good and great. So moving on to the next slide, which is stuck. I don't know for what. Yeah. So we have a slide which is trying to engage all of you with essential types of electronic evidences. All of us are, I believe, aware of all these terminologies, etc. So now we go to, now before that, can I have some more interaction? If we try to compare, where could we find electronic or digital evidence? In what types of devices? Maybe in say 20 years,
system, computer, mobile.
20 years back, computer, mobile, yeah, fine. Something else?
20 years back, we would have said ki matlab, it should have been in the floppy disk or a CD.
Exactly. Yes. Floppy, CD, right? Yes. I'm getting the answers. Yes. Now, if I just modify that particular question to say, do you find any change in the devices or in areas where you find or it's probable to find electronic or digital evidence today? Is there any change?
Yes,
There would
there's
be
a
a
lot of
change.
change there. We can show drawings on clouds, iClouds, Apple Clouds, and different softwares.
Yes, apart from that, something
Or
else? Something else? Anybody else?
Yeah, sir.
dark web.
So basically, nowadays, when we install an app, so it is getting a third party access to it. Like for example, if we give WhatsApp our device location access, so but obviously that server is going to take our log files and save it there.
Right.
So that is also Like for
Yes.
example, if you use a VPN, so but
Yes,
obviously
yes,
the
yes.
VPN company has your IP address, the original IP address that VPN company has that.
Yes, yes. That's right. Any other takers, please? Something else which we have not addressed as of now?
pen drive.
Pen drive is yes, of course. Something else? CCTV, yes, of course. It's a very grave development today. Everything, most of us are being, surveilled in some way or the other, with or without our knowledge, even on the public roads. CCTV, yes. Something else?
Google drives,
Yes,
any kind
yes.
of
Google
software
Drive,
drive.
yes. We have a very smart answer from Advocate Hitesh. Smartwatch. So we see a shift from normal devices, which we said as floppy drives and CD drives and the hard disks, etc. Here we come on to a very different device, which is a wearable, which is a smart watch. So that was a nice input. Google Maps, yes, of course. Mail accounts, yes. So I think we can also address this with stating that with the advent of IoT devices, I think a lot of wearables have also crept into the scene, right? Yes or no? Yes, smart ring. Yes, yes, of course, smart ring. So dealing with this, I think we can move and just to see in one of the slides that I have tried to bring before you. I don't know, the slide is again stuck. Let me check what's wrong with it. Doesn't seem to move. I'll just stop. Okay, let me take it to the concerned slide. Yeah, can you see this slide at the moment? Oh, it's gone back.
Hey. Huh?
Let me start it once more.
So it's also the same example of we are dependent on the online media. Like we are stuck here.
Yes, we are. So I don't know why the slides are not moving. I think I can stop the slide share and still continue. You might be in a difficult position where probably you might not be able to see the slides. I'm sorry for that, but please bear with me. Let me see if I can get that right. What we were discussing is we have a lot of variables which have come in at the moment. So we have a plethora of devices which could include smart glasses, we have a smart watch, we have smart shirt, we have body control GPRS, we have Bluetooth key trackers, we have smart shoes, we have smart socks, we have smart pants, smart belts. Someone stated very rightly, smart ring, smart bracelets. So all of these, things bring in a fair amount of data which is generated through the user, right? Am I audible?
Yes.
Right.
Yes, sir.
Right. So let me check if I can again start sharing it or not. Just a minute. Yeah, can we see the slides?
Yes, sir. Yes.
Yes, sir. We
Okay.
can.
So these are some very insignificant slides. I'm just trying to show you what types of devices were there before and what types of devices are there at the moment. These are all that we are trying to understand. Now, I would like to share with you a few instances as to how in today's days, how important is digital evidence. So I'm just trying to share on the screen. I'm sure you can see it. It gives you a story of a Craigslist killer, Mr. So-and-so, and how he met his victims online, and how he used to probably lure them to his services. And then there were instances where women were were shot and murdered, and then thereafter how the police could trace him because of his posts online. So this is one such instance from which we could understand the importance of electronic or digital evidence. This is another instance where there was Mr. Ross, and he had a pacemaker, and due to his health issues he was fitted with a pacemaker, and there he suddenly had an incident which he reported, saying that there was a fire which broke out in his house, and he claimed insurance. And he also stated that the way he escaped, breaking the window and jumping out, etc. But later on, when the pacemaker data was scrutinized, it was found that the fire was rather created by him, and it was a hoax claim, etc., etc. So these are some instances where we can understand that wearable devices and other electronic devices that are now prevalent with us probably gather a lot of data which could be material evidence in situations as per the circumstances of each case. Does anybody have a different opinion? Please come in. Anyone who has a different opinion,
May I
please
speak?
come in. Anyone who like to add something, please come in.
So am I audible? Hello?
Yes, please go ahead.
So indeed, these devices and these digital evidences are pretty much smart to, get us to a conclusion, but the admissibility of the same is a big question yet in front of the law.
Yeah, we are slowly progressing towards it. We are progressing towards it. At the moment, we are, just trying to understand where can we find these types of evidences. So what you have stated is right. In a few moments, probably we'll try to understand the admissibility as well. So from the types of devices where we could get evidences and where we could get information, etc., we move to this slide. Any technical people here in the group, please? Anybody who is technical? Okay.
Yes,
Mr. Prabhakar, yes, happy to have you here. So,
sir, in fact, now I'm studying in final year, final semester of law at Ratnagiri after retirement. I was actually I'm from Indian Telecom Service. I'm an ITS and posted. I mean, just got retired in 2019 from Department of Telecommunications.
nice to have you here, Mr. Prabhakar.
Thank you, sir. Namaskar.
Yeah, namaste. So this slide, I'm just trying to share with you. On the left hand side, you can see which is stated and captioned as data. And on the right hand side, in the red rectangle, we have some information which is stated as metadata. Anybody who can give me a basic understanding of what he or she understands by the term metadata?
So, sir, basically metadata is something that saves a part of data that is being captured. Like, for example, we can take an example of a photo. So, but obviously, whenever we are clicking a photo from our phone, so in that metadata, we get our location and the device and the resolution and the camera details and the phone details, that whatever the phone has been used to click the photo. So that metadata gets saved into the photo behind the data.
Right. That was excellent explanation. But if I can wrap it up in one short sentence, I would say metadata is data about data. Is that more confusing or is it easier?
It is more of a technical term, sir.
Yeah. So in something, as you can see on the screen, we have data on the left hand side and we have more details of that data on the right hand side, which gives you a bit more of a depth of an analysis of what the data is. And we could take it as this in-depth or a more intense understanding of the data is metadata. Now, a question comes to all of you. Can data be evidence?
Yes, it can be.
Sir,
Yes.
it
Yes.
can be an evidence.
Yes, it can be evidence.
Yes. Can metadata be evidence?
Yes, sir. In
Yes,
some
sir.
cases, metadata
Yes,
can be
yes.
evidence.
Exactly. So here we come with one more situation which distinguishes electronic or digital evidence from normal physical evidence, which is in normal physical evidence, we don't have metadata at all, right?
Yes.
But when we come to the realm of digital or electronic evidence, we have the content of the data which is visible, and then we have a latent or a non-visible metadata as well, which could be looked into as evidence, right?
Yes, sir.
So
Yes.
this makes it more crucial, more challenging for as one of our friends stated here, for bringing it over and making it admissible as evidence before a court of law. Now let's move forward and see. I don't want to put more efforts in this slide where we are trying to discuss types of evidence. We are all aware of it. We have oral and documentary, etc., etc. So we won't waste time on this. We will go and try and understand hearsay rule. I'm not going into it. I don't want to make it more complex. But yes, have we heard something of the terminology which is called the best evidence rule? A yes or a
That is
no?
primary evidence. Best evidence
Yes,
is
sir.
also
Primary evidence. The one who sees from himself.
I would suggest we just resist ourselves from concluding into a fact of that the best evidence is primary evidence. Since we are dealing with electronic and digital evidence, I would suggest you to take the terminology as the best evidence rule, is because the courts prefer that the best available evidence is what that needs to be brought before the court of law. Can we have a complete consensus on that for the time being?
yes, sir. You are right, sir. We do
Right.
agree.
Right. So having agreed upon that, now if we try to understand that the Indian law does not encourage hearsay evidence, yes or no?
Yes, sir.
Yes, sir.
Yes. But now we come to a situation as what my friend has stated before. Suppose in a case of murder, we had a murder which has been committed in broad daylight and it was in a public place, and the public place was having CCTV cameras fitted by the public administration as well as the private parties, whatever. Now what I'm trying to focus upon is when the investigation start and when the IO gathers inputs or materials to be brought before court, he gets this piece of bite from the CCTV, which clearly shows the video of the fact how the murder took place. And this CCTV is brought before the court. Please don't jump the gun. Just wait. We are just progressing. What I'm trying to say is, can we say that if this CCTV footage is brought with the required procedures of law, can we state that this could be best evidence?
Yes, sir.
Yes,
Sir,
yes,
in
sir.
this particular case, yes.
Yes,
Because
Yes.
already
Miss Shruti, can you
tried,
just elaborate why you said a yes?
sir, because you have said that
Mr.
the
Prabhakar, please hold on. Please hold on. Mr. Prabhakar, please hold on. Miss Shruti, can you please elaborate?
Sir, because according to the situation, it is the best evidence that the parties can provide or the investigation officer can provide.
I can't say that you're wrong, but can somebody better it? Can somebody improve it? Mr. Prabhakar, you can go ahead.
Sir, when investigating officer collects this particular evidence, and that too after observing all the formalities, then in this case, this would be the best evidence. I mean, this particular evidence is as good as primary evidence.
Again, I say, please hold on. Don't get into the hassle of primary, secondary. Somebody else who can explain it. Mr.
Sir,
Prabhakar,
this
you're not wrong. Mr. Prabhakar, you're not wrong. You're fine. You're on the right track. But something more? Yes. Please go ahead.
Sir, this can only be the true evidence because if we consider people, then they can also fake things. So this can be true.
That is bang on. That is why it is said that if the other parameters are met, this could be the best evidence because it is being seen by a device which cannot change, which cannot become hostile, or which cannot lie. Am I correct?
Exactly, you are
Yes.
perfectly right.
So, having summed up the fact that though hearsay evidence is not the rule of law, but when it comes to digital or electronic evidence, we have a situation where we get such types of evidence which are not the traditional style of evidence, but yes, it still can be the best evidence. Do we have a consensus on that?
Yes, sir.
Yes, sir.
Okay, perfect.
Kindly repeat it.
Yes, please. Yes, please.
Kindly repeat it, sir. How can we say that it's the best?
As we just discussed, when it meets the required parameters of law, we'll discuss that later on, but we're just keeping it short. And if the CCTV footage which has been produced meets the other parameters of law, this could be the best evidence because this is something which cannot change, which cannot alter, which cannot become hostile, which cannot lie. Mr. Mayank?
Ji, sir, thank you.
Yeah.
Sir, shall I
So,
add something, sir, here, if you
yes,
permit?
please. Yes, please.
Sir,
Yes, please.
evidence is definitely, I mean, it is the perfect evidence. Perfect evidence in the sense, it can never lie. Not only that, it can even create other evidences also. It can, I mean, we can call for other evidences which we could not have called had there been not this particular CCTV footage.
Yes, I agree. I agree.
Nearby
I agree.
evidence like people surrounding who.
I agree. But we were on the CCTV footage at the moment. You have taken the thing a bit forward, but yes, it's a very proactive way of thinking. You're right. I do agree. Now we come to we come to a scene of how traditionally the Indian Evidence Act addresses evidence as primary and secondary. So I do think that all of you understand the basics or the basic provisions of the Indian Evidence Act. Yes or no?
No, sir.
Okay. That no makes it more challenging for me. I thought we might get a yes so that we can move forward, but no problem. Now, if you see Chapter 4 of the Indian Evidence Act, it starts with what is oral evidence. And then when we go to Chapter 5, we come to documentary evidence. So sections 59 to and 60 deal with oral evidence, and 61 onwards it takes on to what is documentary evidence. Now here I would request all of us here not to jump the gun, be slightly patient, and just bear me for a minute. Let me take you forward with what is primary and secondary, leave it aside. Okay, we can get back to that. And yeah, we have just finished this, so I don't. Yeah. So I would like all of you to pay some attention to the screen now before you. Okay. Now, since we are dealing with an introduction to electronic evidence, I would like you to pay attention to what is being just shown to you. If we understand the definition of evidence under Section 3 of the Evidence Act, this particular definition of evidence was slightly tweaked. How was it tweaked? It was tweaked by bringing in the terminology evidence means and includes all statements which the court permits to or required to be made before it by witnesses in relation to matters of fact under inquiry, such statements, etc., etc. All documents, including electronic records, produced for the inspection of the court. Now, what I request all of you to just bear in mind is that phrase electronic records. Do we understand what is electronic records? Yes or no?
Yes, sir.
Okay.
Yes, sir.
Okay. So I don't need to take you through what is an electronic record. Yeah. So evidence as tweaked by this particular phrase which was introduced to it, which is electronic record. So evidence includes electronic records. Now I would just take a while to reiterate what is an electronic record as defined where. Can somebody give me an idea where is it defined? Electronic record.
So that is, I think, if I'm not wrong, Information Act.
That would be IT Act Section 3 under subsection A.
It is IT Act Section 2, subsection 1, clause T, Tango. So I'll just read it out for all of us. It says electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfetch. So if we look at the definition of electronic record, it is pretty exhaustive. Although we might not understand that in the first reading of it, if we try to understand what is data, data itself is has been provided a very elaborate definition under Section 2, subsection 1, clause O for Oscar, under the Information Technology Act. So if we just sit and then try to break up the definition of electronic record, we will understand that it is a very exhaustive definition. Now, having said that, we will now move to Section 5 of the Evidence Act, which says Evidence Act provides that evidence can be given only regarding facts that are in issue, or, of course, I don't need to go into that depth of it now because there are the definitions of facts in issue, facts proved, facts disproved, facts not proved are very intricate. So I don't want to deviate from that at the moment. We will stick to the electronic or digital evidence scenario here. So these are certain provisions under the Indian Evidence Act which were tweaked up and brought in to meet the requirements of electronic record or electronic form or electronic record, which has been included in the definition of evidence under the Indian Evidence Act. Now I would like to take you all to this slide as to from where did the Indian law gain inspiration to bring in the provisions of Section 65 capital A and 65 capital B of the Indian Evidence Act. It is Section 69 of the Police and Criminal Act 1984 of the UK, from where the particular provision was sort of loaned over or borrowed or maybe inspired from. Now, interestingly, this provision ceases to be law in the UK since 1999. May I know how many of us are aware of this? A yes or a no?
No.
No.
Yeah. So please make note of this. This particular provision was inspired from the previous slide which I showed you, which is already been removed from the law in the UK. But interestingly, for us in India, we still have the provisions of 65A, capital A, and 65B. Now, can someone give me an intro as to what 65 capital A says? Any one of you, please?
Sir, before that, I wanted to ask a question.
Yes, please.
So why was it removed? Because electronic evidence it holds more importance in these days. So.
I'm happy somebody asked that question. I like people who ask why, where, why, how. So thanks for asking that. Now, when we discuss more on 65A and 65B, maybe I can give you a more connect of it. But to just answer you in a very short manner, the Parliament thought it best, while bringing in these aspects which has been under 65A and 65B, which have been inspired from the provisions of the UK Act, you have certain parameters or requirements to be met before digital or electronic evidence can be made admissible, right?
Yes, sir.
Yeah. So when these provisions were brought in, it created a lot of hassles practically before the courts of law, as even what we also face in courts of law today. Practicing lawyers, anybody of you can give me any instances where you have faced a situation and you were stuck and you were not able to go ahead with producing electronic evidence? Anybody who can share? No one? Hello? Am I a bit audible?
Yes, sir.
Yes, sir.
Yeah, suddenly everyone went silent, so I thought I had logged out or what. Okay. Anybody who can share his instance or some doubts? Okay, fine. We'll take it forward, and then in the course of it, I can maybe give you some examples as well. So coming from UK, now we go on to understand what is, okay, I think I missed one provision, 65A. Let me just read it out for you. What does 65A state under the Indian Evidence Act? 65A states special provisions as to evidence relating to electronic records. And it says the contents of electronic records may be proved in accordance with the provisions of section 65B. I believe we are aware of this provision. Yes?
Yes, sir.
Okay. Now we come to 65B, capital B, which says admissibility of electronic records. And here we have a very elaborate section which deals in parts. It has subsection 1, subsection 2, subsection 3, subsection 4, subsection 5. Now, to completely go through this section, I think the time frame prescribed for me is not enough. However, I would like to take you with some case laws so that we can make it crispier and make it easier in a way to understand. So I'll take you to the slides. I was swiping it wrong. Okay. So this gives you a basic idea of what 65B caters to. In 65B subsection 1, it states, I'll just read it out. I'll be slightly fast. Please bear with me. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on paper, stored or recorded or copied in optical or magnetic media, produced by a computer, hereinafter referred to as a computer output, shall be deemed to be also a document. That's a very important phrase. Then it goes and says, if the conditions mentioned here and below are met. So I'll just cut it right there and then come to this particular slide which says what are the conditions to be met. The conditions to be met are elaborated under section 65 capital B subsection 2, which says the computer output sought to be produced in evidence must have been produced by a computer which was being regularly used by somebody. Then it says it should have been entered into the computer for an activity which was regularly carried out on that computer during that during that relevant period. Then it says that throughout the material part of that period, the computer was functioning fine, etc., etc., etc. Now, these are requirements which are brought in under 65 capital B subsection 2. Now, if you have a laid back approach to this, just sit back and just look at what it states. These are requirements which have been brought in just to bring before the court that yes, this is a computer output. Number two, this was the computer which was being used to get to this information which is now brought before court. This computer was functioning fine during that relevant period. That computer was being used by so and so person. These are the details of the computer, etc., etc. So it is basically in the format of letting the court know that this evidence was accessed on this particular device, computer. That computer was so and so's, and the computer was working fine, etc., etc. Any doubts till now? Any doubts till now?
Sir, if you don't mind, shall I add something in so far as 65B is concerned? If you
Yes,
kindly
please.
allow. I just
Yes,
want
please.
to get clarified myself also and just discuss also. Now,
Yes, please go ahead.
You read the clause 65B. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media. Sir, these are not only media, but there are other media also, like semiconductor media.
Yes.
Yes. What the interpretation, what this particular sentence says, in optical or magnetic media produced by computer, there has to be optical, magnetic, and semiconductor or semiconductor. If I am not wrong, sir.
I don't find fault with you because you're a technical man. You think technically, which is absolutely fine. No issue at all. But the fact remains that lawmakers are not technical people. So the fact that the law has been made is one aspect of it. And the fact is, how far is the law covering all aspects of it is another aspect of it. So what you're trying to state is an addition of part that you feel as an individual who is more knowledgeable technically that the law missed out semiconductor, right?
Yes, sir.
Yeah. So this is a debatable issue. If we go into it, we will not finish the class. But the fact remains is that law cannot be expected to include all the aspects and progressions of science and technology. Why is it so? Can you please answer?
Because the lawmakers, we cannot expect that lawmakers have to be technical persons, sir.
No, not because of that. It is because technology has a much faster pace than what law can ever have or ever will have. Technology has a very different pace, as you understand. When the law was brought in at that time, it was more focusing. If you can go through the sections, which I would not focus on that now, it has a very limited focus on what can be brought in as evidence or electronic evidence. Today, we are 20 years away from when the provision was brought in, and technology has taken huge strides. right?
Yes, sir.
Yes. So the fact remains that there is always a gap between technology and the law. But how far does it fulfill its requirements as per the law which is existing at the moment is what we are trying to understand. So what you have said is right. Of course, your knowledge and your thought process is commendable. But the fact remains is that we cannot improve the law at the moment. We need to take it at the way it is. And yes, there are instances where the law is overhauled and is going to change soon. So for now, we will just consider what 65B 1 and 2 just states and what is the purpose of it. So can we move on, please?
Please, sir.
Yes. So having said that, I would just request all of you to pay some attention on the screen now. I'm trying to make it crispier and not more confusing by just bringing in the precedents and the timeline of the precedents, how the law has progressed and how the courts have assessed, assimilated, and brought out the law and interpreted the law under 65B of the Indian Evidence Act. How many of us are aware of this case? NCT versus Navajot Sandhu.
No, sir.
Okay, then I would request you to please take note of this. I have even stated the citation. In this case, it was brought out that irrespective of the compliance of requirements of 65B, which is a provision dealt with dealing with the admissibility of electronic records, there is no bar to adducing secondary evidence under section 63 and 65. Now, how does secondary evidence be brought in and made admissible is elaborated under section 63 and 65 of the Indian Evidence Act. So this was a case which the Honorable Supreme Court said that apart from the fact that 65B is a special provision, but there is no bar in adducing secondary evidence. Now, please understand, I don't want to go into the debate as to whether this judgment was right, whether this judgment was wrong, how far it goes in. It's a very large debatable area. But what I would like all of us to just focus here is what was the vision of the court while deciding this case. So the court says that yes, we agree 65B is the provision which has been specifically brought in by the parliament with regard to how electronic records can be made admissible in court, but it brings in a terminology saying that there is no bar to adducing secondary evidence. So the aspect of secondary evidence which now is brought in even with respect to electronic records comes with this particular case. Are we clear till that?
Yes, sir.
Okay. So thereafter, we have another case here, which is, if you see the timeline, the other one was 2005, this is 2014. And here we have a full bench. We have a 3 judges bench. We have the bench here also. Please go through it. And the honorable judge's name, who was the author of the said judgment, has been shown in bold, Justice Kurian Joseph. So this was a case in which the Honorable Supreme Court laid down the law very firmly. And it said what? It said that electronic evidence, when produced, the section 65B is a complete code in itself vis-a-vis electronic evidence. This was the first finding, that section 65A and B is a complete code in itself vis-a-vis electronic evidence. But thereafter, what it went and said, it said that it made a distinction. Now, before going to that, I will say the court said that so anywhere electronic evidence comes in, 65B has to be met and complied. This was the way in which the Supreme Court looked at it. But down the line in the evidence, towards the end, the Honorable Judge says that suppose the original device is produced in such a situation, that original device which contains the electronic evidence is primary evidence, and in such a situation the requirements of 65B is not required. Am I clear till there?
Sir, so the previous part was okay. That means when the original device comes into picture, it becomes some sort of primary evidence, and it loses, and it goes beyond the. I mean, it goes above the 65B. Now, can you just expound this last part of the explanation, if you
Right.
don't mind?
Right. So what the honorable judge brought out as law from this particular judgment is, I'll give you an example. We have a CD which contains electronic evidence, and we are producing that CD before a court of law. The same CD in which it was recorded or burnt primarily, I may be excused for loosely using the word primarily because I'm a lawyer, I need to be more aware, but I'm using the word not technically, but in the general language to make all of us understand. It is the original CD which recorded or which contained or which burnt the electronic evidence embedded in it. If the very same CD is produced in court, the Honorable Supreme Court said that amounts to primary evidence, and when such evidence is brought before court, the provisions of 65B need not be complied with. Am I clear?
Yes, sir.
Okay. Okay. So here it brought out a situation where a full bench of the Honorable Supreme Court rather settles the scene, which categorically states that yes, 65A and B are a complete code vis-a-vis electronic records under the Indian Evidence Act. But, however, if the original device is produced before the court, which contains the electronic or digital evidence, in such a situation or in such a scenario, 65B need not be complied with, for the reason that such original device which is produced is considered as primary evidence. Are we fair enough till here?
Yes, sir.
Sir,
Okay.
excuse me, sir.
Yes, please.
But any device which contains electronic record would again be electronic evidence only, right?
I totally agree with you. I'm happy that you said that. I cannot deny what you have said. That is the truth. That is the reality. But the fact remains that when a full bench of the Supreme Court says so, it becomes the law of the land. We need to understand the fact that there has been a lot of debates, a lot of challenges, a number of conferences, a lot of deliberations, and a lot of confusion, even with regard to the courts, judges, we lawyers, students, academicians, trying to understand what can and how can electronic evidence be termed as primary or secondary at all. So I think it was from Dhruv Sharma, right?
Yes, sir. Actually, I'm Aditi Sharma, the device.
Yeah, so I was slightly confused. You have a lady's voice, but you have a man's name.
So actually, it's my brother's account. So
That's okay. That's okay. No issue. So what your thought is absolutely fine, which is the right thought phrase, which any right thinking person should think about. But I would again warn us as students of law to understand that when the Honorable Supreme Court extols the law, expands the law, explains the law, interprets the law, we have Article 141, which comes into play, and we don't have an option but to follow it, right? So as of now, we will move with Anwar and see what happens next. After Anwar's case, what happened? Now here we have another case, which is in 2015, which is 1 year after the previous case, which is of Anwar. And if all of you can please see the judges involved in this particular case is Justice Anil Dave, Justice Kurian Joseph, and Justice Banumati. And in this case, what did it bring up? It said again that despite the fact that Anwar states that 65B, when it is brought out and when the primary or the original device is brought in before the court, it amounts to primary evidence. In such a situation, 65 does not required to be complied with and all. This particular judgment goes and says it disagreed with the fact of the other one, saying that secondary evidence in support of the content of the document could be brought in. And it said that, what does it mean when it says secondary evidence in support of the content of document could be brought in without 65B? It means that even if primary evidence is not brought in and evidence is, or the electronic evidence or digital evidence is brought in by secondary in the manner of secondary evidence. Now, I think all of you will have a doubt as to how can electronic evidence be brought in as secondary evidence, or what does the court mean? Let me explain. Now, in the previous judgment, His Lordship Justice Kurian Joseph laid down the law saying that the CD in which it was first brought in, if that CD is produced, it amounts to primary evidence. Correct?
Yes, sir.
Yes.
Yes, sir.
Yes. So in this case, if I say that the same CD is copied again in another CD, and that CD is produced before court, in such a situation, that CD, bearing in mind the judgment of Anwar's case, becomes secondary evidence. Right?
Yes, sir.
Yes. And this judgment by Justice Banumati states, even when such secondary evidence is brought in, 65B is not required. This was the situation brought out in this particular judgment. Now hold on, please don't jump the gun. After these two judgments, we students of law understand that there is differences in the judgments of the Honorable Supreme Court on the same issue of Section 65B vis-a-vis admissibility of electronic records in the court of law, right? Yes or no? Yes. Now, interestingly, another case comes in. This is in 2018, which is Shafi Mohammed versus State of Himachal. And here we have a division bench of the Honorable Supreme Court consisting of Justice Adesh Kumar Goel, Justice U. Lalit. Now, what happens here? Anybody aware of this case? Anybody has read this case?
No, sir.
Okay. So these are very, very important case laws vis-a-vis how 65B has traveled and how it has been implemented, interpreted, and brought out. So please note these judgments. Now here what happened was, this was the factual case was, investigation agencies and law enforcement agencies were facing a lot of flack and challenges in Jammu and Kashmir. Then, where a lot of incidences, a lot of situations where public were, pelting stones, were against the government, were showing a lot of strife and struggle, wherein the law enforcement tried to bring the crowd under control, which resulted in probably incidences of violence, etc. So the law enforcement agencies thought of a situation that how would it be if the officers who are on the ground have built-in cameras on their body when they go for a particular incident. And in such a case, the thought which came out is that once that particular incident is captured by the body camera, if it needs to be produced in court, in such a situation, the person who had recorded it might not be available. And in such a situation where he is not available, and the fact that the visuals would have been transferred or retrieved onto other devices which are produced in court, how to handle the provision of 65B? This was the instance in the case. Am I clear?
Yes, sir.
Yes,
Okay.
sir.
So by this,
Sir, let me add, but this issue got solved in the previous judgment.
yes, please.
This issue, the issue right now, what you narrated, it got solved in the previous judgment.
No, it was not. It was not. There is one thing which I missed, is the 65B certificate. So when in this case, the question was, suppose the person who has recorded it is not available or is not able to give a 65B, what could be the recourse to it? This is the issue which comes in here, which is slightly different from what was solved in the other case. Okay. Is that clear?
Yes, sir.
Yeah. So here what happened is, the court held that if the electronic evidence is authentic and relevant and the same can certainly be admitted subject to the court being satisfied. Please read the words. Subject to the court being satisfied about its authenticity and procedure for its admissibility may depend on the fact situation, such as where the person producing such evidence is in a position to furnish, is not, I missed it, is not in a position to furnish 65B. This is what was considered in Shafi Muhammad. And in such a situation, the Supreme Court held that where it cannot be produced or where the person is not able to produce it, in such a situation, subject to the satisfaction of the court about its authenticity, 65B certificate can be given a go by. Am I clear?
Yes, sir.
Yes, sir.
Okay. Then what happens? Then we come to the last part of how 65B traveled. Now, please make note of this case, and I request all of you to please read the full text of this judgment. This is, at the moment, the deciding judgment on how the law stands with regard to the admissibility of electronic records vis-a-vis Section 65 capital B Indian Evidence Act for us. So please note the citation, and please also note that this was again a full bench consisting of 3 judges, and the judgment was authored by none other than Justice R.F. Nariman. So what was that which was considered here is, we'll quickly go with it. So in this, in short, the full bench concurs with the judgment in Anwar PV, which reiterates that yes, 65B is a complete code vis-a-vis electronic records. It also goes forward and concurs with Anwar PV, stating that when the original device is produced, it is primary evidence, and in such a situation, a certificate under Section 65B of the Indian Evidence Act is not required. But apart from laying down and reiterating this, this was a case which was given for, a reference. It was referred for this, to settle this confusion. So although it stated that Anwar PV is the right law, which says that for electronic evidence and digital evidence and admissibility of the same, 65B is a complete code in itself. It has to be complied with. However, as what Anwar stated, if the original device containing the electronic evidence is produced before the court, in such a situation, 65B certificate is not required. Now that was settled. Something more happened. There were instances where it considered Shafi Muhammad, etc., and Thomas Bruno also. So for settling the situations and the issues that cropped up there, Honorable Justice Nariman took the help of these two maxims. Can you see the maxims on the screen?
Yes, sir.
Yes. So these maxims, lex non cogit ad impossibilia, which means the law does not demand the impossible. Now, this comes in tune with which fact? Can anybody tell me? This maxim addresses which fact that we are trying to understand? The law does not demand the impossible.
Sir, the person who recorded was not, I mean, if not available, then.
Exactly. And see the next maxim, impotentia excusat legem, which means where there is a disability that makes it impossible to obey the law, the alleged disobedience of law is excused. So this also, yes.
You kindly expound, sir, this particular maxim, if I mean, if you have time.
I didn't get you in the last words, please. Can you repeat?
This next maxim, if you kindly expound little, if time permits.
Yeah, sure. No problem. In simple, the law requires something should be done, right? Mr. Prabhakar.
Yes, sir. Getting, sir. You please go ahead, sir.
Yeah. So the law expounds that something should be done, something should be followed, something should be complied. But in practicality, if that compliance becomes impossible to obey, then that particular inability or that alleged disobedience of law is excusable. You get that?
Yes, got it, sir.
इसका मतलब जो करना चाहिए नियम के अनुसार अगर आप प्रैक्टिकली नहीं कर सकते हो तो दैट डिसोबीडियंस माफ है.
जी सर, इट मींस बियॉन्ड वंस कंट्रोल.
एग्जैक्टली ठीक है. सो विद दैट नाउ हाउ वी स्टैंड टुडे इज ऑन द बेसिस एंड द स्ट्रेंथ ऑफ द जजमेंट इन अर्जुन पंडित राव खोटकर वर्सेस कैलाश कुशन राव गुंट्रेयाल. This is in the year 2020, 7 SCC, page 1. This is what we now follow in courts of law. With that, I believe I could cut across at least the basics of what we tried to understand in this particular session under the caption Introduction to Electronic Evidence. I'll leave it to you. Questions? Please shoot your questions.
Sir,
Ji.
Just a little elaboration on civil aspect of this evidence, because normally we have spoken about the criminal applicability. How do we apply in the civil cases? More particularly, I'll just narrow down the scope, wherein suppose there is a matrimonial dispute and there is a recording done by a spouse. So whether that can be permitted in the court to be produced?
Yes. See, Indian Evidence Act does not distinguish between civil or criminal proceedings. Okay. Indian Evidence Act applies to both.
Correct.
So in a situation of what you've just stated, in a matrimonial situation where you have a recording, which could be an audio, I'll take a video recording, something of that sort. Audio recording. Audio recording ka to situation is clear from very long back. It doesn't have an issue.
Yeah, there was a thing that you cannot record a person without the consent, and that amounts to invasion of the person's privacy. So
all that comes in only now after the judgment of the Honorable Supreme Court in Puttaswamy's case. Okay, so the privacy aspect is, of course, a huge breakthrough in the Indian law. But if you see the evidentiary part of it, Indian law does not state that evidence which has been brought in clandestinely or by a sting operation or without the knowledge of somebody else, it does not distinguish.
Okay. So it can be brought in.
In the US, it distinguishes.
Okay.
So our laws are slowly gathering pace, and now we have a situation, as you rightly said, that the privacy of the other person has to be looked into, this, that. So it is debatable. I will not be able to finish it in today's class, but I'm sure when we move ahead in the advanced part of it, we will deliberate on it very elaborately. It's interesting, and I'm happy that you have been thinking on it and you're trying to apply it. So this is commendable.
Thank you, sir.
Please bear with me today. We have already overshot the time.
Yes,
so
sir.
Please,
thank you for.
Please bear with me today.
Yes,
but please
sir.
keep these questions with you. In the advanced classes, we will surely discuss it.
Certainly. Thank you very much.
We can extend the class, sir. No problem.
I need to move out for something else, which I'm scheduled as well.
No problem. No problem. As per your convenience, sir. There is no problem.
Any other questions with regard to what has been shared, please? A quick. Any questions?
So I have a question, but it may require some time, sir. So maybe we can discuss in the next session.
Sure.
I want to discuss some situation. I want to just discuss some situation which I came through. That's why.
Ji, boliye.
So basically, there may be some situation where the author of the document is the accused himself, or the person has passed away. Now, since now the court has said that the section 65 has no role, and 65 bravo has to be complied with, how to deal with those situations at that time?
नहीं, थोड़ा सा एक बार please repeat करिए. I didn't get the initial part.
There can be a situation, sir, where the author of the document, like suppose if there's a photograph in the accused mobile or the mobile phone of a deceased person. Now the 65 bravo certificate may not be possible because accused cannot be compelled to provide it.
No, 1 minute. I'll give you. I got your question now.
Yes, sir.
I'll just give you a scenario where we were discussing this. I was taking a class for the higher judicial officers in Delhi,
sir,
where one of the judges had this question to me.
Yes, sir.
So, उनके court में क्या हुआ? It was a murder case which he was attending to, and वहाँ पे situation ऐसा हुआ कि the accused is behind the bars. Okay.
Yes, sir.
Accused's father comes to court and says, मेरे पास में एक CCTV footage है जिससे आपको ये क्लियर हो जाएगा कि मेरा बेटा जो accused है उस दिन में, उस टाइम में, उस पर्टिकुलर इंसिडेंट में वो जगह में था ही नहीं.
Yes, sir.
So here the accused side wants to bring in, the best evidence to show that he has been framed by the law enforcement. He is totally innocent. But you know what happened in court?
Yes, sir. No, sir.
The judge said he cannot produce it.
That's what I was coming to, sir.
इसीलिए मैंने आपको ये example दिया.
Yes,
this
sir.
is exactly why I gave you this example.
Yes, sir.
So, my knowledge as a practicing lawyer,
yes, sir,
it cannot be said that CCTV cannot be brought in evidence.
Yes, sir.
Evidence is not only to try to bring out the incrimination of the accused.
Yes, sir.
Evidence is also to bring out the truth, which alone should prevail in trial.
Yes,
Are we
sir.
clear?
Yes, sir. Yes, sir.
Even as an investigation officer, the Honorable Supreme Court has been clear in multiple judgments to say that an investigating officer does not have a duty only to gather incriminating material against the accused. He has a duty to gather all such evidence which is relevant and material and bring before court. And it is only the court which will decide, based on the evidence produced, the guilt of the accused.
Understood, sir.
So I think आपका problem का solution फिलहाल के लिए है.
Yes, sir. Yes, sir. Yes, sir.
Yes.
To a great extent. Further, I think we can clarify.
बिल्कुल.
Yes.
बिल्कुल. Sure.
Right,
so
sir.
I think with that, can we wrap up for the day with your permission?